All right, thank you. Thank you for coming to the Ask the EFF panel. It's always a pleasure to be back here at BSides and talk to the community. My name is Kurt Opsahl. I am the Deputy Executive Director and General Counsel of the Electronic Frontier Foundation. I assume that most of you are generally familiar with EFF, but just briefly, if you are not, EFF is a nonprofit civil liberties organization dedicated to defending your rights online. So we fight for things like privacy and free speech and innovation, trying to make the future one we would want to live in. One of the things we do with this community in particular, we have our Coders' Rights Project, where we advise researchers and presenters about the risks they may face in conducting research and in presenting that research, to try and make sure that conferences like BSides are able to go forward without things like temporary restraining orders and the kind of ugliness that might occur. But fortunately, things have generally gone smoothly. But if you are a security researcher, one of the things we do is provide advice. But here's the thing: this is not the place for that. You want to have that in a privileged, private conversation. So this is the Ask the EFF panel. We invite people to ask any questions they may have. But if it pertains to you and your particular legal situation, that is best to be a conversation that we have at another time and place. So with that, we'll briefly introduce our crew here and then turn it over to questions. So Stephanie.
Hi, I'm Stephanie Lacambra. I'm the criminal defense staff attorney at EFF. I work on pretty much the deployment of government surveillance technologies in the criminal justice context when it comes out in the context of criminal prosecutions. So when criminal defenders need help trying to challenge everything from automated license plate readers to cell site simulators to digital device searches in their cases, they come to us, and I will help marshal our resources for them.
All right, thank you. Nate.
I'm Nate Cardozo. I'm a senior staff attorney on the digital civil liberties team at EFF. I do cybersecurity, privacy, free speech, encryption, export controls, and I work on our Who Has Your Back report. And as part of my job, I counsel people like you.
I'm Catherine Trendacosta. I'm a policy analyst on the activism side of EFF. I work on net neutrality, ISP privacy, fair use and IP, and sort of the DMCA ban on breaking encryption.
I'm Sydney Lee. I'm on the tech projects team at EFF. I spend about a third of my time working on CertBot, which is EFF's client for Let's Encrypt. And the other 2/3 of my time I spend trying to bring that success we've had on the web to email. So we're working on a new project called Start TLS Everywhere. And for those of you who haven't had the enormous pleasure of being an email systems administrator, Start TLS is the equivalent of HTTPS for email. So we're working on tooling to make Start TLS deployment easier and better.
I'm Andrew Crocker. I'm another one of the attorneys on the civil liberties team. I do national security and surveillance work, and I work with both Kurt and Nate on our Coders' Rights Project and Who Has Your Back.
All right. Well, thanks again for everybody for coming, and we're ready for your questions. Does anybody have a question to begin with? All right, right here in the front row.
So in light of GDPR that's going on in the EU, and in light of Zuckerberg's defense of Facebook's performance at privacy of their data, do you see any of that propagating from across the ocean to Washington as far as protecting our information? I realize that's not a three-letter company that I'm talking about. I'm talking about a private company, but do you see similar legislation requirements?
All right, so the question was about the GDPR, the European Data Privacy Regulation, and whether in light of it coming out in Europe and going to effect on May 25th, and then Facebook, Cambridge Analytica, will that come to the United States? I think this is a very interesting question. I think it will come to the United States in the sense that companies who are in the United States, the bigger ones in particular, all have European customers. So, and they have European offices. They can't do the "haha, you can't get me" approach. So they're going to have to deal with the GDPR one way or the other. One of the things that was interesting that coming out of the Facebook and Cambridge Analytica is Facebook put out there that they were going to apply the GDPR's privacy protections worldwide, that it was not just going to be for the European residents. So we'll look at that with some interest to see how that rolls about. Whether there will be a GDPR legislation here, probably not in the same form. There are very different views on privacy in between Europe and the United States. Also, while the GDPR does a variety of things designed to protect your privacy, there are also speech implications for what it does. In particular, the right to erasure, so which is a new term for what was previously more commonly known as the right to be forgotten. And while you can be very sympathetic with somebody who had an episode in their past that was relatively private, got onto the internet, and they kind of wanted to be forgotten, in practice it is often being used by like public figures, politicians, in order to sanitize their history, so that people don't consider that when evaluating their candidacy. So that would run up against the First Amendment here if you tried to say that something could not be published, even though it was factually true. So in the U.S., we have a very strong sense that if it is a factually true statement, then that is your right to be able to say that. So that aspect of the GDPR probably wouldn't work under a constitutional system. And then more practically, the European view on privacy is very much that privacy is a human right. It is an inherent right that one shouldn't be able to sort of waive, while much of the U.S. system is looking at more transactionally, where the key is to make sure that people are agreeing to a particular deal, but once they've agreed, then the buyer beware. So it's a little bit of a different system. All right, question back there, sir. Yep. All right. So the question is about SESTA FOSTA, a recent bill that passed Congress, where they put some limitations on Section 230 of the Communications Decency Act to make it easier to go after service providers who host racy content. It was being positioned, at least by the proponents, as an effort to combat prostitution and sex trafficking. And the question is, what are we going to do about it? Nate?
So one of the parts of the question was, are we planning to fight it in court? And the answer is, we're not going to say right now. We are looking at all of our options, but we haven't decided exactly what the best path forward is. In terms of a best practice guide for service providers, that's actually not something that we had considered. It's not a bad idea. So let's take that back to the team.
All right. Another question, please? All right. This is an issue that we're aware of. I think none of the people here have worked on the Who Is issue. But to give you sort of the broadest strokes is that is an interesting sort of conflict that under the who is system, you are supposed to be able to identify who is behind various domains. In practice, a lot of times people will use a third-party intermediary so that you look up who's behind a particular domain, and you come to a company, and then you have to get the information from the company. But they're sort of the gist of the who is system is to say, who does this belong to? And this, of course, is personal data that would be covered by the GDPR. And the GDPR is designed to provide greater privacy protections. So these things do have some conflict. The ICANN, the Internet Corporation for Assigned Names and Numbers, is working on this, trying to sort of figure it out. I know a lot of people who do like attribution forensic research, trying to determine where a bad actor is coming from, rely heavily on the who is system as a clue to get there, and have some interest in being able to track down who the users are. And at the same time, I of course have sympathy for those who wish to have it private. A lot of times domain names are used for political speech, and it is useful to be able to do so as anonymously as possible. But I don't have a current update on that.
My suggestion is to look up Brian Krebs's latest writing on the issue.
All right, so the question was about the Cloud Act that recently passed as part of the budget bill concerning the ability to get access to information stored overseas. Who's up on the Cloud Act?
So the Cloud Act does two main things. One is it clarifies that when U.S. law enforcement get a warrant and serve it on U.S. providers, that they can get that content wherever that content is held. So that had the effect of mooting a lawsuit that was already in front of the Supreme Court about whether Microsoft had to respond to a warrant for data that happened to be held in Ireland. And the answer is now yes. So that's one thing it does. It also allows governments, the US and other governments, to enter into bilateral agreements where they can each request data from companies about citizens held either in the United States or in the other country. So that would be a case where Google holds data about a non-U.S. citizen in the United States. The U.S. enters into an agreement with, say, the U.K. The U.K. can request data on one of those citizens. So theoretically, it does not affect data held about you, a U.S. citizen held in the United States. They would still need a warrant to get access to that information. So they still have to go either to a U.S. court, DOJ would, or a foreign government would have to go through the Department of Justice to then get a warrant.
All right, here at the front row. All right, so this was another GDPR question looking about where it might go in Canada and in the U.S. So I think, well, as an initial matter, the U.S. is a bit different from a lot of the rest of the world. Like, it is extremely common for a country to have a data protection law, data protection, government officials, and this is not part of the U.S. system. I am not an expert on the Canadian system, but I do know that they do have some data protection laws. So they may move around to be something like the GDPR. A lot of the data protection initiatives have originated in Europe and spread elsewhere, but it's actually commonplace all around the world. As I was mentioning before, the U.S. is a bit different, sort of philosophically, and for some, good reasons. We have, again, like the First Amendment puts a greater primacy on the ability to speak freely without the government telling you what to say than on protecting privacy. So if these things come into conflict, there is balancing tests, like the court will look at balance out the interests, but there is a very strong tendency that if something is factual and true, you can definitely say it. And this would include private information. So it seems that it's likely that Congress will do something about Facebook and Cambridge Analytica, because there's a problem, there is something that has got the national attention, and when there is a national attention problem, Congress feels the obligation to do something. That obligation is fulfilled by doing anything. It doesn't actually have to solve the problem. It just has to be that, like, we have now responded to this. So I highly suspect that Congress will do something in that sense. Whether it will actually be ultimately a useful something remains to be seen.
It's my perception that we're losing the net neutrality war, or eventually will start losing the net neutrality war. Can you comment on some of the work that you're doing, or some of the work that's out there?
So the question was about net neutrality, that we're losing the net neutrality war, but what can we do?
So net neutrality, I know that it looks really bad, like it's really depressing, but it's actually way less awful than it looks, in the sense that the thing the FCC passed, the Restoring Internet Freedom Order, which is what they called it, is incredibly vulnerable. It's not written well. And so, as I think a lot of people know, I think it's 24 states have sued over it, in addition to Mozilla, the Internet Association, and a bunch of others. It's currently going to be in the DC Circuit. They're going to hear it. I think they set a schedule but they set a schedule for it. There's going to be a hearing on it, and we'll see what happens with that. And that's in the future. The thing about net neutrality that is bad is any resolution that comes is going to come in a long time because of the way that our government works. But I fully believe that there will be, that we lose in the short run and win in the long run. What was definitely going to pop up is you'll see net neutrality preserved in states. Washington and Oregon both passed and signed net neutrality legislation that restored all of the protections that the 2015 Open Internet Order had. California has 3 net neutrality bills currently pending. One's already gone through the Senate, one has a set of hearings this week, and I don't know the state of the third, which is a little bit more tangentially related to net neutrality than the rest. And we actually had a day of action on the California net neutrality legislation on Thursday, and we got word from Sacramento that the phones were ringing off the hook and please stop. Tell them to, like we had the ability to tell people to stop calling. So it's an issue that people think is really important, and because 83% of Americans support net neutrality, no one can say publicly that they don't. So what's actually more dangerous than anything the FCC did or that order that they issued is to keep an eye out for laws that sound like net neutrality but aren't. Marsha Blackburn has one, Senator Kennedy has one as well. Both of those leave out certain protections that are vital for net neutrality. They ban blocking and throttling, but they don't ban paid prioritization. And so we need to agitate for an actual bill that does those things. But the good news is everyone likes net neutrality. It's a really hot issue, and you need to look like you're on that side. So we have a lot of leverage there.
All right, question back there. Yes, indeed. So the question was, does EFF track right for repair? And yes, we do.
Yeah, we track right to repair. We do a lot of work on the bills that are going through. We testify in support of the right to repair bills. I think we actually, it's either happened already or is happening this week. I can't quite remember that one of our attorneys was testifying for the California right to repair bill. So we have the right to repair bills. There's also, in reference to right to repair with the DMCA, which bans circumventing any sort of digital lock or encryption on things that you own. Those hearings were held last week. 2 of our attorneys testified in DC about that. They'll also be testifying in Los Angeles in a week, and I will be there as well, to explain why it is necessary to break encryption on things you own so that you can fix the things you own, which seems pretty straightforward.
We've also done a lot of work with Kyle Wiens and iFixit on right to repair. That's a really solid resource. And we've worked in the automotive security space to ensure that right to repair extends to cars. The auto manufacturers are dead set against it. And so we want to be the voice of the tinkerer.
On that note, apparently during the hearings, the reason brought up for why you shouldn't be able to break the encryption on your car was because you might use your car to rip a DVD.
All right, that's fair. All right, another question is there. Let me first see if anyone in the back. It's hard for me to see. I just want to check to see there. All right, there we go. There's 2 of you right in a row. The further one back first. Sir, that's you. Yeah. All right, so the question is about the recent article in the Washington Post about stingrays found in DC. And I guess we are going to invite up to the stage here our colleague Cooper Quinton, who, Cooper, who is working on that very issue.
Hi, yeah, so there were, I think, 2 questions. Has anybody stepped forward claiming to operate them and the legality of them? Is that correct? So that'll be for you. But as for the first question, nobody has stepped forward to claim ownership of them, which is not surprising. And it's actually really hard to do attribution on stingrays, which is, I think, we can give DHS a lot of credit there when they say they don't know who operates them. There's a very good reason for that. It's very hard to tell who is operating a stingray. As for the legality of it,
So on the legality front, I mean, in terms of like looking out what is being sort of broadcast to make some determinations of that, we think that is generally cool. It's not like there's been a specific case that has dealt with this very issue, but if you have something which is attempting to detect whether there is a stingray by observing what is going on in the air, that's not particularly high risk. If you wanted to mess with them, that starts to get into sort of more interesting grounds. Because, of course, as a baseline, there is things like the Computer Fraud and Abuse Act, the federal anti-hacking statute that discusses getting unauthorized access to a computer. Stingray is a computer because basically everything except calculators are computer, and they would be computers if it didn't specifically say not calculators. But then there's other things that the people who are putting them up are probably not going to go to like the, FBI and say, hey, someone messed with my stingray. We're assuming that these are not U.S. government stingrays, but one of the things about them is that people don't want you to know who did them, and to fight you in court, they'd have to do that.
So apparently there's a question is, what is a stingray? A stingray is a fake cell tower that is operated by someone other than the cell company in order to usually locate a cell phone. Also at times it can be used to read the content of text messages or voice conversations, or even data, depending on the capability. I would also note that if you're planning to mess with or interfere with the stingray, just remember that most of the bands that are used by cell site simulators, as well as actual cell towers, are licensed spectrum. Broadcasting in a licensed spectrum without a license is not permitted.
So let me clarify the naming thing a little further too. So we talk about cell site simulators, MC catchers, and stingrays, and we often use these terms interchangeably. A cell site simulator is probably the best technical term for what people usually think of. It is a device that is actively masquerading as a legitimate cell site to get your phone to connect to it, to get some amount of MC or location or metadata or data off of it. So this is an active device. It's broadcasting and trying to get your phone to connect to it. There's also passive devices, which could probably be more appropriately called MC catchers, that are just trying to pluck that data out of the air without actually broadcasting anything. Kurt brings up a good question. What's an MC? MC stands for International Mobile Subscriber ID. This is the unique ID that's associated with your SIM card. This is your subscriber number with the phone company. And it's a unique ID for your SIM card, so it's good for tracking you because nobody else will have this ID. So that's the difference between an MC catcher and a cell site simulator. And Stingray is a brand name, a popular brand name for a cell site simulator that was sold to a lot of law enforcement in the US and abroad earlier in this century, and has now been supplanted from the same company, a device called the Hailstorm, which purports to have much better capabilities and the ability to intercept 4G communications, whereas the Stingray could only do 2G, I think.
We'll also hear Triggerfish or Dirtbox. The brand names are myriad.
All right, so just to wrap that up, if in fact one of you is interested in messing around with stingrays, this is just the sort of thing that one would want some legal advice on. So this is not, as we said, the time or the place for that, but proceed with caution. All right, next question. I'll go midway in the back there. Oh. All right, so the question was back to the GDPR and the right to be forgotten, and proposing a step 1, become an e-citizen of Estonia, step 2, ask Intellius and other data brokers to forget you. Well, that's an interesting strategy. I'm actually, I didn't realize Estonia was so cheap. For most places, if you want to buy into citizenship, it requires hundreds of thousands of dollars. Oh, okay. So the GDPR, by the way, it actually covers residents of the European Union. So if you are a citizen and you're here, it theoretically doesn't cover you. And if you're not a citizen but are there, it theoretically does. So in that sense, citizenship is not the key. But let's just assume you go to Europe and do the same thing. So it'll be interesting to see what happens, because sort of under the GDPR review, you would have, in the first instance, the right to ask for that to be forgotten, and they would have to fit that into some sort of exception to allow it to continue. I have not really sort of analyzed how that would play out. I mean, for the most part, we're actually opposed to the right to be forgotten on free speech grounds. But I do know that some people, once the GDPR goes into effect, Max Schrems and others are planning on testing some of its features right away. So we will have an opportunity to see how that pans out. All right. So we had one other in the back there, which, yeah, in the green hair. All right, so the question was about the Digital Millennium Copyright Act and our challenge to the constitutionality of that act, where we represent Matt Green and Bunny Huang.
As near as I can tell from every meeting we've had every week, we are still waiting to hear back on that. We filed, and now it's just we're waiting for the court to tell us what we should be doing next.
Work in progress. All right, here in the second row.
So in light of jurisprudence that determined that tracking
All right, so the question was about, given the Supreme Court's decision about putting a GPS and requiring a warrant to put a GPS on a vehicle, how does that play into things like ALPR, automatic license plate readers, and other forms of tracking? Andrew?
Sure. So you actually said something very important, which is that the Supreme Court held that the placement of the GPS on the car was what implicated the Fourth Amendment, what was made it a search. And you had 5 justices who were not the majority opinion say that the long-term monitoring also seems to implicate reasonable expectations of privacy. So unfortunately, as is so often the case with the Supreme Court, we have a kind of gesture in the direction of something interesting and useful for other things like license plate readers or cameras, but no guidance on exactly how long-term that would be, and it's not the holding of the case, so it sort of has to wait for another day. So you have lots of efforts to sort of analogize in just the way that you're saying, tracking in public over a long period of time, correlating lots of things the way some of these other technologies do, seems problematic and should sort of implicate expectations of privacy, but we haven't had definitive rulings. So you've had some technical efforts to say how long is too long. There's some well-respected scholars who say, I think it's 2 weeks. And you can read that paper and sort of get into why that is. It may be that we see a bigger change in a case that's in front of the Supreme Court right now called Carpenter, and that's about whether tracking cell phones via cell site data from the provider implicates reasonable expectations of privacy. Up until now, it's been thought that under older case law, because it's obtained from a third party, you don't have any expectation of privacy in that. And the reason that might be useful for some of the things you're asking about is it may upend all of these ideas of what is a reasonable expectation of privacy and how does it fit in this sort of tracking in public and intermediary world that we live in. So I think it sort of remains to be seen how that'll play out. That case should be decided by June, so we actually may see a very big change in Fourth Amendment law.
Okay, well, we are running out of time here, so we'll have one more question. How about you, sir? So the question was about backdoors and the going dark problem, or sometimes they're called front doors, you say, whatever you call them, but weakening encryption to better allow law enforcement access and what we can expect. Nate, you want to hit that one?
Yeah, so your question also said, what do we expect in terms of legislation? I think that the legislation that we'll see is not going to be from the US. I think we're going to see something from Australia or the UK before we see anything from the US. Our senator from California, Dianne Feinstein, led the charge in the last Congress against encryption and to mandate backdoors with her colleague Richard Burr from North Carolina. There's been some mumbling that that bill might be reintroduced. There's been some mumbling that it might not be. The Department of Justice, Christopher Wray, the FBI director, and a number of others have been lobbying pretty hard on the Hill that something must be done. Their message has been undermined pretty significantly by people like Celebrite and Grayshift. It's been reported in the press that for $50 you can unlock any phone on the market. Celebrite, of course, is the Israeli company, and their solution is a little more expensive than $50, but they also claim the ability to unlock every phone on the market. So when we see people like Cyrus Vance, the district attorney of Manhattan, say that he has 7,800 iPhones in active criminal investigations that he can't unlock, his words are ringing a little less true in front of Congress right now. Is something going to be proposed? Probably. What do we expect that to be? I have no idea. The thing that I'm more worried about than legislation is backdoor pressure. I have had clients who are encryption software developers who have had visits from 3-letter agencies, and they're shown, pictures of children being beheaded and saying that your software has enabled this, and if you don't give the U.S. a backdoor, their blood will be on your hands. That's the kind of pressure that I'm more worried about. My nightmare situation, my nightmare scenario isn't legislation mandating backdoors. That's possible, but we can fight that in the courts. My nightmare scenario is silent capitulation from the companies, and that's still definitely on the table.
All right. Well, that brings us to the end of our Ask the EFF panel today. So there are some more questions out there. Sorry we didn't get to everyone. We will be around a little bit afterwards here, and also there's an EFF booth up on the top floor if you want to try and catch us at another time. Thank you all for coming. It's always wonderful to be here, and we look forward to talking to you some more. Thank you.